Next up on Capitol Journal, we're joined by Alabama Attorney General Luther Strange. Welcome back to the program.
Thank you for having me.
Nice to see you as always.
Glad to be here.
I want to begin with a ceremony you took part in today, and it was to honor our fallen police officers. Tell us what was going on.
Well, there was a beautiful solemn ceremony today on the lawn of the Capitol at the Fallen Officers Memorial, honoring the officers we lost in the line of duty in the last year. And it's something I wouldn't miss. It's a very moving memorial to the families and all law enforcement officials around the state who put their lives on the line for us every day. And so I was glad to participate in that with the governor and others. And I point out, Don, that we honor our fallen officers probably more than any other state because our two prominent monuments on our Capitol are their fallen officers memorial, which is one of the nicest in the country. And then we also have a monument to Albert Patterson, who was an attorney general who was assassinated in 1954, and there's a statue in his memory. So not so many governors and congressmen and senators, but a lot of law enforcement, which is really appropriate.
I believe we lost 4 officers in the last year, right?
We did. We lost 4 officers, and it's always tragic, and it's a reminder, and I'll be traveling south later in the week to honor some other fallen officers. They lost 2 in South Alabama recently, and so it's a tragic reminder of the price that our law enforcement, men and women pay every day for us to keep us safe.
Mm-hmm. The ultimate sacrifice, so to speak.
The ultimate sacrifice, and we can't thank them enough.
Indeed. Now, I want to move to a big event for you recently. It was your first appearance, was it not, before the United States Supreme Court?
It was. It was a highlight for any attorney general or any lawyer for that matter. And I haven't done an official survey, but I think that I may be only the second attorney general in Alabama's history to actually personally argue a case before the United States Supreme Court. I know General Pryor did several years ago. I'm not sure that any others did. It's a rare opportunity because cases just don't often get there. But when they do get to the Supreme Court, they're usually very important cases, as you know. And this case was particularly important because it dealt with the First Amendment rights of public employees. The particular case involved one of our biggest public scandals in years, the two-year college scandal,
right.
And a gentleman who testified in that case 8 or 9 years ago and who lost his job. And so the question was, does he have First Amendment protection to testify in grand juries and before in federal trials? And I took his side. I think it's an important principle. We want to encourage our public employees who know something about corruption or something going wrong to be able to testify without being afraid of retaliation. And so that was the principal position that I took in that case. And again, it's a very rare opportunity, and we'll now wait to see what the court does. But I hope that we win, and I'll be 1-0 in the Supreme Court.
Well, it's a case that's being watched very closely, a whistleblower case as it's caused by many. And as you mentioned, employees being able to testify freely and not fearing retaliation. Now, I know there was some debate by this gentleman who worked for a community college, whether he was testifying as a government employee or whether it was as a private citizen, and
right.
Which is protected and which isn't.
Exactly, and that's the tension that the Supreme Court has recognized. There's a category of public employees like police officers and child welfare officers and others whose typical job, part of what they're paid to do, is to go testify. And they have fewer constitutional rights than the gentleman that I defended, Mr. Lane, because the government has a legitimate interest in making sure that they're effective and competent and they're consistent with the message and so forth. So we tried to make that case on behalf of Mr. Lane, recognizing there are some government employees who have fewer rights, but that's appropriate given their role and the ability, the need for public employers to have some control over what they say and how they say it.
Now, at the same time, Mr. Lane, I think, was seeking in his case some damages against the then president of the community college where he worked. And this was an interesting dichotomy in this case because at the same time you didn't feel, I believe, that president should be held liable for damages.
Exactly. So what we were debating and discussing in front of the court were constitutional principles. And I believe strongly that Mr. Lane had the constitutional First Amendment protection that all government employees in his position should have. The other issue was the person he sued, the president of the two-year college at the time, and he sued him for personal damages, making him personally liable for his termination. And we took up the position in that case that government supervisor was entitled to rely on the law at the time. The law at the time, as he understood it, and as I think it existed, gave him flexibility to do that. And so we argued he had qualified immunity, the legal term, to do what he did. That'll all be sorted out when the court sends it back down to the local trial court. I think what will happen is they'll find a constitutional right to First Amendment protection for this person. But I think it'll go back to the trial court to say, well, you know, if you did fire him, was there some other good reason to do that? What are the facts? And that just really hasn't been developed yet. But I don't want to have our good government employers who are supervising employees be subject to personal financial risk if they're just doing what the law says at the time. Mm-hmm. Two very important principles. There is a tension there, as you said, but I think it'll work out in the end once it's sent back for final adjudication.
So what was the experience like being before the Supreme Court? Did it meet or exceed expectations?
Well, it really did, because you are so close. I mean, not as close as we are, but you're extraordinarily close to the the chief and the 8 other justices on the Supreme Court. So as a lawyer, it is the most daunting experience. As much practice and experience as I've had in the BP case and before lots of judges, when you're standing in the Supreme Court, it's unlike anything else, because you don't get a lot of time to just give your explanation. They start asking you questions, and so you have to be on your game. And so I did devote quite a bit of time to prepare for this. And usually when you're before the Supreme Court, you're going to be arguing issues that have ramifications nationwide. So the issues we're talking about, the protection of these government employees, will apply not just to folks here in Alabama, but it'll apply to employees all across the country. So it was an honor, an incredible honor, and a real privilege.
Well, good luck to you, and as you said earlier, we hope you'll be 1-0 in the Supreme Court.
Thank you.
This week you also were the lead author in a friend of the court brief that was filed in the state of New York concerning a ban they have on many semi-automatic weapons.
Right, and that was an important case to me, and not only to the state of Alabama, but to 20 other states across the United States, almost half the states in the country. And the issue fundamentally is the defense of the Second Amendment when it comes down to it. And in this particular case, New York passed laws that were so draconian to the extent that they prohibited guns that would be used by normal citizens. They couldn't establish that it would reduce crime in any way or make people safer. And so we think they went way beyond their constitutional authority and joined in to support the folks in New York. So it wasn't a case that we originated, but it was a case that we joined in because of the fundamental Second Amendment principles involved, the right to keep and bear arms. And it has a practical effect, Donna. Interestingly, as you know, and I think you reported on this, Remington just moved 2,000 jobs, manufacturing jobs, from New York to Alabama. They're going to be employing those people in Huntsville. And I think that is in large part due to the fact that we respect the Second Amendment here in Alabama. They don't in New York, frankly, and that has real-world consequences. But as to our involvement in that case and the other states, it really is a constitutional question at heart.
And key in this conversation, as you pointed out, is many of these guns that would be affected by this ban are guns that everyday ordinary citizens would ordinarily own.
Exactly. So when you start tampering with the rights of ordinary citizens to carry guns that they would normally use for sporting purposes or defense, you're not achieving any purposes you claim to achieve. They haven't dropped any crime rates. They're not making anybody safer, but they are eroding our Second Amendment rights. And that's a principled stand that I think is appropriate for Alabama and dozens of other states to take.
Maybe it was just too broad a law?
We think so. It's on the 11th Circuit, the Second Circuit, their appellate circuit there, and we'll see. It may go to the Supreme Court. There's an active area here, as you know. There's a strong component of society operating mainly in New York and California and other states that want to would like to totally restrict, frankly, the Second Amendment. And if we don't stand up for it, then shame on us.
Now, on to the recent dismissal of your suit over gambling on Indian lands in Alabama. It was ruled by a judge that Alabama had no authority over gaming on Indian lands. You have taken exception with that, and I think you said you were looking at an appeal of that ruling.
Correct. Since I came into office and inherited really a kind of a mess, as you recall, on the whole gambling arena, we made the decision to just deal with this in court, let everybody make their case. And you have sort of 3 categories. You've got the counties like Jefferson and Madison and St. Clair and Walker that you enforce the law against illegal slot machines. It's really not an issue. You've got some counties here in Alabama that have a different opinion. Greene County, Lowndes, for example. We've tried to get that resolved in court, and we have cases pending there. Then the third area is that we inherited and that we're dealing with is the Indian tribes. They claim they have tribal sovereignty. We think that it's illegal for them to do something on their lands that's illegal in Alabama. And it's that simple. And we took that to the court, and you're correct. The federal district court ruled against us. They did not rule on the legality of the machines. They said that we don't have jurisdiction. And so our next step would be to appeal that. And the hope in all of this is, to go back to my promise when I was elected, is to treat everybody the same, give everybody their day in court. Once we get a final determination from the highest court, then we'll know what the rules are, finally said and done, so this endless back and forth will be over, and we'll be able to say, look, the final court has spoken, here's the law, and then we move on to something else. Is
it a sticky argument, this federal protection versus your contention that if it's illegal in Alabama, then it's illegal in Alabama?
Well, it's a difficult proposition because the Indian tribes are supported very strongly by the Obama administration and the National Department of Justice and Department of Interior. They've made a stated policy of promoting gambling on Indian lands. They are the federal regulator, and they're paid by the Indian tribes to regulate the Indian tribes. It's a very cozy arrangement, and so it's difficult. You know, they are entrenched. They started from paper bingo years ago, and now they've got what they advertise as casinos. You know, no one's ever passed a law or a resolution or anything in Alabama to authorize any of that. And of course, they don't pay any taxes. But again, my goal is not to set the gambling policy in the state of Alabama. It's to take a mess, sort it out so that whether you live in North Alabama, South Alabama, or if you live on an Indian reservation, you're playing by the same rules. The courts have spoken, and that's what I promised to do, and that's what we're going to do.
Speaking of gambling, a couple of weeks ago there was a raid on some gambling establishments in Greene County, right. And it sparked an old debate anew, again, if you will. These operations have contended that their machines are legal machines, and the state contends that they aren't.
Right.
And that's the crux of the matter here, as far as you're concerned.
It is, and we've tried our best to deal with it in court, and we do have lots of cases now pending in court where I expect we'll get a resolution sometime soon. I think there's just so much money involved. You know, it's very difficult for people that can make that kind of money to resist going in and setting up these facilities. But again, that's not my decision whether we should have gambling or not. It's just to make sure the law is enforced fairly across the state.
Mm-hmm. Now, a lot of these counties, like Greene, for instance, and Macon counties too, contend that these operations are the main economic engines of their reason, and that these raids are punitive in nature.
Well, I'm all for employment, particularly in areas like Greene. And as a private lawyer in the economic development world, before I ever got in politics, I represented major employers in Greene County. And so I understand the difficulty and the challenge and the need to get good, high-paying, long-term jobs into those parts of the state. I personally think, putting on my economic development hat, that if you base your local economy on these kind of machines and low-paying jobs and stuff, you almost create a barrier to other companies coming in. And I say that as having represented Hyundai when they came to Montgomery. Companies look to what is the climate, are you enforcing the law, and lots of other factors. And when you have a controversial industry like that, it just tends to make people say, well, maybe I'll go somewhere else. So I think, ironically, even though they certainly employ people, I guess, I have no idea what they pay or how many jobs it really is, it's not a long-term solution, and I'd really rather see, and have worked personally, to try and bring established jobs like the Hyundais, the auto suppliers, people that will give you good benefits, long-term employment, and really contribute to the schools and the county as a whole.
A couple of weeks after those raids in Greene County, the local sheriff gave these businesses the go-ahead to reopen again. Is that skating on thin ice? Or?
Well, it's frustrating because it's not the way typically law enforcement treats these matters, like in Jefferson County, Madison, and other counties, where they have been consistent in enforcing law from the very beginning. But we, again, are going to deal with this matter in court. We're not going to be, I'm not going to be drawn into any kind of confrontation. This doesn't have anything to do with civil rights or any political agenda. It's just making sure that everyone is treated fairly. If you live in Jefferson County, Greene County, or South Alabama, we don't have one law for one place and one law for another place. And so I'm hoping we can work through it, get a final decision from the courts, and then we can all move on, because we've got a lot of important things to do.
Finally, Mr. Attorney General, we spoke with you at the beginning of the legislative session about a package of bills that you were behind that would have streamlined the death penalty appeals process here in Alabama. They did not make it out of the session this year. Did time just run out?
Well, Don, I'm very, I would have to say I'm disappointed, very disappointed that legislation did not get through. We're proposing legislation that would streamline the appeals process so that people who have been sentenced to death, the ultimate penalty, are through the process in 10 years instead of 20 or 30 years. We have 16 people now who are on death row, who've exhausted all of their appeals. And the victims, there's thousands of victims of people who, victims of these crimes, and they are not getting justice because we're not moving the system forward. Everyone's rights will be protected. The people on death row's rights will be, they'll have every right. They won't lose any rights. But it doesn't make any sense, and it's horrible for the victims to have to wait decades to get justice in the system. And so we're going to push very hard again in the next session. And I hope the legislature will deal with that very promptly.
Mm-hmm. Was it more so that time ran out versus any kind of opposition to the legislation, as far as you can tell?
It probably got a little bit of both. There is a strong, there's, as you know, strong opposition to the death penalty. There's some groups that are just strongly opposed to it, but it's overwhelmingly supported in Alabama. It's the law in the state of Alabama. It should be imposed and enforced speedily, and so we'll bring it back. And I think we have a strong legislature, a good law and order legislature, and I hope they'll get it done this time.
And again, it's important to point out in this discussion, as we did when I spoke with you about this at the beginning of this session, that this is not to deny any due process to death penalty inmates.
Exactly. What you have now is you have long processes, 13 levels of appeal, and they go on forever. You can dual track or streamline that process. Everyone's rights are protected. But it streamlines the process, and it's been done before in other states. It's constitutional. Texas, for example, average person is on death row less than 10 years. Here in Alabama, it's closer to 18, and we're arguing now about someone who's been on death row for 34 years, which is just not justice.
So you will bring the legislation back next year?
Absolutely. It's very important. It's very important to the law enforcement community, and very, very important to the victims and the families of the people who were victims of the crimes.
Indeed. Attorney General Luther Strange, always a pleasure to have you on the program.
Thank you so much.
Thank you for being here today. And Capital Journal will be